Good afternoon, everyone, and welcome to GP Premises Update with Cautionary Tales, based on our experiences of supporting GP practices with their premises issues over many years, Gemma. I'm Rebecca Beardsley, Legal Director here in the Healthcare Property team, and
I'm Gemma Pouncy. I'm a partner in the Healthcare Property team, and we're both specialist solicitors, and we work with pretty much solely GP practices of their property issues. So it's very much our specialist subject.
Now, we've had a couple of questions in from attendees ahead of today, and we'll cover some of the themes raised, but we'll follow up separately in respect to your specific queries. Now, I've got a bit of a technical thing here. So if you have any technical issues today, please check your Zoom settings in the Zoom banner first. Leave us a message in the chat box below, or alternatively try disconnecting and rejoining the session. If you have any questions throughout today's webinar, please pop them in the Zoom Q&A box rather than the chat box. Any questions in the chat box might get missed. The speakers will aim to answer as many questions as possible, time permitting. The webinar is being recorded, and we will aim to send you a copy of the slides along with the recording in the next few days. Now, what are we going to cover today? So, next slide, if we can, Amy. There we go. So today we're going to cover the importance of keeping your title up to date, third-party occupiers, whether that's under leases or licenses, or if they're undocumented, managing your costs on a refinance. We're going to look at a compliance health check, keeping track of your documents and deadlines. We're going to look at some case studies on missing land, which comes up more than you think. We're going to look at the VWV portal, notional rent and rent reimbursement under the premises cost directions 2024, some grant funding, case studies, and considering the right team at the right time for you. Now, over to Gemma first for the importance of keeping your title up to date.
So, as I mentioned, we specialise in GP premises, and we see all the time different situations where there are issues which start small, they become bigger over time. And so it's really important, whilst you're dealing with your day job, you've got lots of considerations day to day. And so thinking about the legals of your premises can sometimes go on the back burner, but it's so important to keep it up to date. Now, one of the key things is deciding whether you want to keep the property within your partnership with the working GPs and other partners, or whether retired partners will be able to retain an interest. You need to make a distinct decision about that, rather than just ending up in a situation over time where it doesn't reflect your expectation. And alongside that, there can be tax considerations, for example, and also the practicalities of what to do if something does happen that isn't necessarily planned. So there's all sorts of complications that can come up. I think there can be people who just vanish, they leave the practice and don't stay in touch, so you might not know how to get in touch with them. We see again and again that perhaps someone's retired and moved abroad, or they've gone to work abroad perhaps. We've had situations where former partners have died, and we've had to deal with all of this after the fact. And the longer time goes on, the more tricky it is to sort these issues out. Making sure that things are properly documented. So things like having your transfer instruments, your deeds of covenant for incoming partners or release for outgoing partners, making sure that the mortgage is kept up to date. The different lenders have different requirements for their mortgages as to who exactly needs to be named on that mortgage. Is that up to date? Do you need a deed of variation? And you can only have a maximum of 4 partners named on the legal title for your property. So who are they going to be? If you've got more than 4 partners, do you have, historically, you might perhaps have said the senior partner, the ones who have been there the longest, have earned the right, as it were, to be on the title. But in actuality, quite often we find that it's sensible to have the newest or youngest partners named. Because it can cause problems, can't it? If someone leaves and then it's not updated, it's much easier to keep it with the younger ones, to try and reduce the frequency with which you have to update these things.
And ultimately keep the cost down for you.
Keeping the cost down is the key point, because all of these complications, the more complexity you have, the more time it takes to sort it out, the more expensive it gets. And so it's definitely in your best interests to keep it as up to date as possible. So we see these things again and again, don't we, Rebecca? We've got lots of situations where we have problems with titles because like I said, it's gone onto the back burner. And so we've got a couple of case studies now, which you wouldn't believe how frequently these issues come up. So case study number one, we've got our GP practice here. And to start with, we have 4 people, they're all partners, they're all named on the title, everything's very, very straightforward. But then time goes on. And so we've got Dr. Black, and Dr. Black, unfortunately, has died. And happened unexpectedly, and you can't always stop these things from happening, of course, but that has happened, we've got to deal with it. Dr. Red, as I mentioned, is retired and just fallen off the face of the planet. Nobody really knows where to find them, no contact details, and so we've got to investigate where they are so that they can sign the documentation.
My favourite one of those, Gem, was we had a retired partner who'd gone on a round the world cruise for approximately 2 years. So trying to track them down at a port somewhere to get them to sign something was quite fun.
Yeah, and similarly, we've had other situations where there's been people who have gone travelling and have had to fly back from where they were travelling to in order to sign documents. So it can be really difficult with those sorts of things. Dr. Green is a happy story. Dr. Green is a love story. Dr. Green fell in love with an Australian and moved to Australia. And then we have Dr. Blue. Now, Dr. Blue is still around, lives locally, but on retirement, there was a bit of a falling out, and so just refuses to sign any documents. And again, we see this more often than you might imagine. So that's happened over the past 5 years. And at this point, we now have 3 new partners who own their beneficial shares. All of the shares have been bought in and out over time. But the title is still in those initial 4 partners' names. And so we've got to try and unpick how to deal with this. That we might have to instruct a tracing agent to try and find the missing person. We might have to wait for probate on the deceased person and deal with the executors of the estate, who quite often are going to be very upset, understandably, at having to deal with this when they thought there was nothing further to do. Their late partner had been bought out, and so they didn't think there was any paperwork needed. With the person who's fallen out with everybody, sometimes they just choose to be difficult for no readily apparent reason. There's not even necessarily a big bust up has happened. They just sometimes don't want to make life easy, do they?
They've left.
Yeah, it's not their problem.
Money, they dealt with it, they believe it all should have been done and leave it for the partnership to sort out.
Absolutely.
But unfortunately, we can't magic their signature, so we do have to track them down and encourage them to help us with it.
Yeah. And I mean, in that situation, we can't force people to sign things. And it could even get to the point, although touch wood, it doesn't happen very frequently, that you might have to apply to court to have the documentation completed, which is not in anybody's best interests. Now, you might think that this only applies to if you own your property, but we see it all the time with leasehold as well, don't we?
We do. Leases, it can be a bit complicated as well. So for those of you in leasehold premises, you'll know that at the end of your lease, hopefully you've got security of tenure, which means you're entitled to a new lease on substantially the same terms. But you're only entitled to that and to follow that process if the right people are on the title, reflect people in occupation. If it's not, it can complicate things. Now, the lease is held on behalf of the partnership, and we do try and make sure we go through and advise you as best we can to make sure it all happens. But if partners have left who are on title at the point you're looking to renew, it can really complicate things and really increase your costs as you get litigation advice on what your position is. There's also issues around dilapidations and covenants at the end of the lease and who's paying for what. And if the old partners are still on title, technically the landlord could go straight after them. And it depends on what the partnership agreement said behind that at the time for any indemnities in respect of any liabilities that they may face. So as on a personal level, when you leave, just make sure all those loose ends are tied up.
And if you're unsure, take advice on it. And generally speaking, your advisors can very quickly determine what needs to happen, if anything, or give you the reassurance that you don't need to do anything further. So moving on to the second case study on this, this is a reflection of a long-standing transaction that I've been managing, where again, it started off nice and straightforward. 4 GPs owned their property split in equal shares. But it's changed over time, and the decision was made that it didn't have to stay within the partnership. And so what happened, Amy, if you could just click through a few times, because it will just demonstrate there's one partner who's died and left his share to his wife. There's several new partners who have bought in. A partner retired and decided to keep his share, and the other partners thought, oh, that's a good idea, I'll do that too. More new partners, lots of division of the property. It's all very, very complicated. And so the property has been divided up, the ownership has been divided up. The title hasn't been updated, and so registered to 3 retired partners and 1 deceased partner. The trust documentation is also out of date. So what the 25-30-year-old trust document says does not reflect the position on the ground as to what everyone thinks the ownership and the split of the costs and so on should be. The bank has come calling because suddenly the property isn't held by the practicing partnership. And the loan terms require that to be the case. And so they've started to call in their loans. The ICB aren't very happy because they say that there should be a lease in place because the ownership of the property doesn't match the names on the contract. There's also stamp duty land tax payments due because it's no longer within a practicing partnership, it's now in a property owning partnership, which attracts a tax consideration. And again, it's just another example of it's a big mess, and it is taking a very long time and a substantial amount of money to sort out. Whereas these things are all possible. You can keep your property with retired partners, and their widows can retain shares, and it's all achievable, but it has to be done in a more proactive way rather than reactive, to ensure that you protect yourselves against liabilities and you can protect against problems arising down the line. So those are just a couple of examples of difficulties that can come up, which sound like they're exam questions, and it sounds like it can't possibly be the case all the time, but we were struggling to think of only a couple to come up with to explain these situations, because we see it very, very regularly.
In fact, a member of the team, Molly's joined us recently, and we were just laughing yesterday that every job has its unique elements to it. With healthcare, there's always something that's a little bit tricky.
Absolutely.
Not straightforward, but that's what keeps it interesting for us. Anyway, so I think moving on to the next slide, Amy, please. So next, we're just going to have a quick chat about third-party occupiers. So if you've got freehold or leasehold premises, and you've got other people using your premises, hopefully they're nice and documented, either under a lease or a license to occupy. Sometimes tenancy as well. Now, the most important thing here is to make sure you understand the lease or license and your own and your occupier's obligations. You'll be surprised how many people really don't appreciate the fundamentals of those arrangements until it's too late and a problem arises. Now, you could be missing out on income or prejudice your position by not following its terms. One of the things that's come up quite recently, there was a whole raft of activity around pharmacies the last couple of years as Lloyd's sought to exit the market a bit. And what we found when we were looking at various applications to assign those leases on behalf of GP practices was that a number of the rent reviews that were due for pharmacies had never been carried out. Some of them are RPI rent reviews, it's quite common in the pharmacy world. And in one occasion, it was a 6-figure back payment that was due to the practice. We thought we were going to have a massive fight over it, but it turns out that they were really on the ball, actually, the pharmacy. They knew it was due, but they just had it in a separate side account in case it never got asked for. And we're able to pay it up pretty quickly. But that 6 figures, with all the GP practices we work with, we know the bottom line is pretty tight these days, made a huge difference for that client. So I really encourage you to understand the documents in terms of your rent review, what you're entitled to, and make sure those rent reviews are carried out in a timely manner.
It's also receiving things like insurance rent, isn't it? And contributions towards service charge, because if you as landlord are paying out for repairs, for example, and if your tenant is liable for a proportion of those repairs, then you really need to be recovering that sum, don't you? Because otherwise you're essentially paying towards their business.
Absolutely. And with costs escalating in the last few years, in terms of utilities particularly, but also things like insurance. So with pharmacies on site and the number of drugs they've got in their stockroom, actually the premium's often weighted because of them, and they're being on site for you. So there's a nice bit of money to be had there in terms of sharing cost liabilities. So check your documents, make sure you're covering everything, and your accountant's going to be key on that. So whenever they do the final annual returns for various things and balance the books, they should be making sure actually who should actually be contributing to this, and what contribution should we be getting from them. So stay engaged with your accountants on that.
And ask them questions. And again, if they're not sure, then you can liaise with solicitors and have that conversation. Everybody can talk to one another and make sure that everybody knows exactly what you should be claiming.
Absolutely. Now, if you occupy your lease yourself and you've got a sublease down to third-party occupiers, you've really got to make sure that on rent reviews, everything marries up in that paperwork. What you don't want to happen is that you've got a gap between the rent you've got to pay up and the rent you're getting in for that specific part of your property. So it's really important it all flows through. And so at the point you enter into that documentation, you get proper legal advice, okay? The other thing just to be aware of really is that whenever you've got anyone using your premises under formal documentation, if you get a notice from them, we're all very friendly and try and be helpful and want people to be able to do what they need to do and get on with any works or anything like that. But sometimes you've really got to pause. If it's a formal notice you've received, don't acknowledge it, get it just listed as soon as possible. If it's an application to assign it, that means transfer it to somebody else or do some works, etc. You'll be under obligations to not unreasonably withhold and delay consent. And any delay there could really prejudice your ability to refuse that if it's not something you want to happen. So timely advice is really essential there. The other thing just to bear in mind is that when you're putting these obligations in place, if you own the building, you'll have a funder most often. And so you just got to keep them in the loop when you're putting these arrangements in place and make sure their consent's been obtained where it's required. And if it's not actually technically required, if it's not going to be a registrable lease, just keep them in the loop to make sure they're happy with the arrangements and they know what's going on in the building. It's really fundamental to banks that they can get vacant possession of that building. If you're naughty, can't pay the bills, can't pay the mortgage, they need to step in and sell that property. So any third party that goes into occupation will be an issue for them because they need to get rid of them as well as you if they have to do that if everything does fall over, which hopefully it's not going to do. But the key takeaway really for third party occupiers that have leases and licenses is that you've got to read the document. And if the person that knew about it has left, nominate someone else to take responsibility to make sure you understand what's in there. And if you need us to do a headline report and have a phone call with you to talk you through it, we're very happy to do that. Appreciate it's not your day-to-day language that you come across in these documents sometimes, so we're always happy to support you in upskilling yourself in what's in that paperwork, so you know who's responsible for what and how to take things forward.
And I think that sort of institutional memory point is really important there, because the thing about partnerships is people change all the time, not just the partners, of course, but employees who may be really involved with the negotiation of these documents. And so 5, 7, 10 years time, they may not be there, and you might not really understand why something was negotiated in the way it was or what position you came to. And so making sure you have that handover as well as possible when people leave, and seek advice when you need it is really key.
Yeah. My favourite one recently with this, and someone maybe on the call that this is familiar to, sorry for that, is we were doing a refinance and then there was a license at the back to use a space and it wasn't documented. Basically, they've been using this right of way and there was a gate at the end. And one of the questions to get indemnity insurance to make sure that they could continue to use it and get the bank comfortable was, is the gate ever locked? And the response that came back was, we lock it one day a year because that's what we've always done. But nobody knew why. And it had been passed down from partner over the years that on this day of the year, but I think it was like around Easter time, on Good Friday, you always close that gate just for the day. But they had absolutely no paperwork to back it up and why it was. It's just one of those things. So those kind of reasons and rationales for doing things, yeah, that collective knowledge needs to be put down somewhere to pass on. Anyway, the next thing to talk about to occupiers is actually undocumented occupiers. So it's actually very common in GP practices to have lots of different people using your building. You're delivering a holistic healthcare service, and so lots of people come and support you in doing that. However, if it's a regular thing and they're coming to use your space and at the exclusion of other people, it really is important to try and get that documented. If you've got a head lease and you are putting people using your space without getting consent for that, you could be in breach of your head lease, which could actually put you at risk of having that terminated. Similarly, as we've mentioned the bank point earlier, if you're letting people use your building without documenting it properly, they could be accruing rights to stay there, which is going to be a problem for your bank if they ever want to step in if you can't service your mortgage and they want to sell the building. Now, if you receive rental payments from undocumented occupiers, you also might have an issue with your rent reimbursement or notional rent, because if you're receiving an income for space you're getting full reimbursement for, that might be taken off your next review. And if it's not secured, so they could actually walk away tomorrow, you may end up having a bit of a gap and not getting full recovery for your premises. The other things to think about here in terms of disputes. So basically undocumented occupiers, the main call we get is when things go wrong and there's a gap. So we'll get a call from you saying, well, we thought they were doing this. And they said, well, they thought you were doing this. And so the classic thing is something like insurance or upkeep of something. And they thought you were maintaining the boiler. You thought they were maintaining the boiler. And then it breaks. So no one's been doing the repair bit. So it becomes a really big issue. And then we've got a dispute that costs lots of money to sort out. One of the classic examples of this on the flip side to being a GP owner occupier is, of course, the NHSPS lease regularisation issues that we've seen over the last few years, where NHSPS inherited a state where a lot of leases were in place, undocumented occupiers, and that was in 2012, when we are still supporting practices trying to get paperwork in place, and they remain undocumented because of the massive service charge issues and the understanding the basis they were in before the switchover. So it's really important to document them where you can. Now, if we move on to managing your costs on a refinance, I think, Jem, you're going to take this one.
Absolutely. So I manage an awful lot of refinance transactions and we deal with the main banks very regularly. So we've got a really good understanding of what their requirements are likely to be, and also know people to speak to when we need some sort of more unusual agreement. And because, as you said, things like undocumented occupiers, they happen so frequently with GP practices. I would say that it's really important to make sure that your lender really understands healthcare, because something that might be acceptable in GP land, as it were, would not be a standard practice for, I don't know, an office building or retail premises or something like that. Now, because we understand sort of the bank's requirements and so on, we see a lot of regular things which can hold up transactions or, again, increase costs. And we, as we've said, we know that you're very stretched and everyone wants to save costs where they can. So just a few tips on things to do to manage that process and try and get things through as smoothly and as cost effectively as possible. As part of a refinance transaction, particularly where we're jointly instructed by both the practice and the bank, we have to complete a report to the bank. And that will include doing things like searches, raising inquiries, and it's similar sorts of things to what you'd have if you were purchasing a house, isn't it? All the sort of background information to make sure that you as owners or the bank as lender aren't going to be liable for example, a massive amount of environmental compliance work, something like that. So things like when we send the inquiries to you, ensuring that the replies that are provided are prompt and complete, and asking for a call if need be. We can talk things through because we appreciate that what makes a lot of sense to us, it's our day job. It doesn't necessarily always follow that it will make sense to you. And so that dialogue is really important. So you can say, oh, actually, I don't know what you mean here. What is it that you want? Other really straightforward things like having up-to-date insurance and sending your policy and schedule and wording over, making sure that it covers the actual cost that the bank requires it to, because the valuation of the premises and the cost to reinstate those premises can be really quite different, especially these days. We've seen construction costs rise hugely, haven't we?
Yeah.
In recent years, and so you may be surprised at the value that you need to insure against, but that's something that, again, you can take advice on and update in the process of your refinance. And checking as well whether you've done anything that might infringe the policy. Are any of the questions not quite right? Have, for example, you had an extension built that isn't actually covered by your insurance policy? It's always really important to make sure that it's all up to date and you've reviewed those replies to your insurers really carefully as well.
I think on that, when we pick up on refinance, we highlight what the bank requires on your insurance, and it's in our reports to you. But what we tend to find when we get a little revisit a couple of years later, when partners changing, that on the renewal, the things that have been advised the bank needs aren't always followed through. So again, it's that sort of collective collection of information of what we need to consider on there and capturing that information somewhere, so you make sure you remain compliant with the bank's requirements on that going forward.
And again, it's one of those things that it won't be a problem until something goes wrong and you have to make a claim that isn't covered, and then it all snowballs. You had an example, didn't you, of premises not being covered?
Well, yes, that's more I'm not a fan of the insurer, where they wriggled out of it, and they will wriggle out if they can, which is really unfortunate. But one of the key things on that as well is that the insurance shouldn't be in the name of the partnership.
No, absolutely.
It should be in the name of the individual partners on the legal title. Because the partnership isn't actually the entity that's being insured here, it is the owners on behalf of the building, on behalf of the wider partnership. So that's one of the common things we do see. So please just do check your documents, name the individual partners, and it's not the name of the partnership.
And again, the people that you deal with at your insurance provider might not understand this. They might need to be pushed. Yes, and again, another thing is ensuring that retired partners are around to sign the paperwork. The same sort of thing as we've mentioned already about being abroad or not able to find them. It's really, really key and can hold up a refinance considerably, which can end up potentially with things like redemption penalties on your previous lending. So making sure you've got a big lead in to any deadline is really key. So I think we're going to move on to the compliance health check now.
So kind of tied in with having a house in order, really. So there's lots of things with your premises you need to make sure are kept up to date. Some of them are listed on this slide. So we've got the Health and Safety at Work Act. So any obligation of this act, including any applicable requirements regarding adequate standards of ventilation, etc., all need to make sure you've got regular checks and you've got your paperwork in order for that. The Equality Act 2010 to make sure you've got ease of access and adequate sound and visual systems at your practice to remove the barrier to the employment of disabled people. We've got the fire precautions you've got to consider. So these include provisions for safe exit from the premises in accordance with the regulatory reform fire safety orders and the building regs. Now, these may need to be signed off by the local fire authority and have regular checks to make sure that they remain compliant. Then we have things like the Legionella and asbestos reports. Now, you need to carry out risk assessments and get professional reports done to check your building on these things. And the really, really important thing is it's not just about having the report, it's making sure that you actually carry out any recommendations in a timely manner and you diarise and manage any annual checks that are required and make sure they happen. Okay. There's also things like electrical and gas equipment. You need to make sure they're regularly tested. Now, I happen to know some PCNs in my local area are actually grouping together and putting in block contracts to make sure those annual checks are happening to share the costs, which is, I thought, a great idea. And overriding all these standard compliance checks, actually, you've got in your premises cost directions in Schedule 1, you have 2 sections there in terms of the compliance standards you need to keep the premises in order to keep the contract. And if you're not compliant with that, you are at risk of losing your reimbursement under your contracts, which obviously is something we really want to avoid. So check Schedule 1 of the premises cost directions. It covers statutory and contractual compliance obligations, and make sure that you are on top of all that. Now, the other thing just to check is, we mentioned earlier, again, one person often is responsible for these things. It's good sometimes just have a little internal audit and say, actually, I know we've just ticked off, we've done it again, annual check, check. But actually sometimes every couple of years just to go, actually, what are we doing? And are we doing the right thing? Is it time for a full report and review on that or not? And just making sure that that's also happening. This ties in actually, Gem, quite nicely to the next slide, in terms of keeping your documents and deadlines and keeping track of them.
Absolutely. Just before I move on to that, I just want to remind people about the Q&A box. We've had a few questions come in, which is great. We've got a questions and answer section towards the end of the slides. So please do keep them coming if you've got any particular questions, and we promise we will cover them off. We haven't forgotten you. So keeping track of documents and deadlines. Again, this is something we see very regularly because of that turnover within a GP partnership. And sometimes these organisations have been active for many decades, and so the background can be huge. Now, exactly what you're going to need to keep track of is really going to be dependent on your property, your situation. There's a few examples on the screen of different things that you should know where to find. But we very regularly find that perhaps one person has a system in place. They know exactly where everything is, whether it's in a paper file or it's in a filing system online, or whatever it might be. And perhaps they go off sick, or they're traveling, or on maternity leave, or they've left. And no one else really knows where to find all these things, or even if they exist. So you need to make sure to have a clear understanding of who's responsible for what and where everything is, essentially. So again, there's just a couple of examples that we've had where missing documentation has caused big issues. And so if we could move to the next slide. So missing land, you wouldn't think that this would happen, but we see it all the time. Again, things like unregistered parcels of land, bits of the property that have been registered in retired partners' names, and bits of the property held under different arrangements. Now, this generally happens because GP practices often grow up over time, don't they? They'll acquire bits of land from different people at different points.
Yeah.
And generally speaking, at the land registry, you can't consolidate those parcels. They have to stay separate. And so this can cause issues where down the line, something's been missed. Now, the plan that's showing on the screen here, we were instructed on a sale, and when we were instructed, it was the red bit that we were told about, parcel A. And as you can see, that's the vast majority of the premises, but it became apparent that there was also the little blue triangle, parcel B, which thankfully was registered in the same names as parcel A, so we had a big tick there, but it was parcel C that caused us problems, the yellow section that sort of curves around. Now, our client was absolutely certain that they owned this parcel of land, but it was registered to a completely different organisation. And so we had to do quite a lot of digging on this. Now, because of the technology and the data that's now available to us, and the different systems, and comparing plans against aerial views and all sorts of fancy stuff we can do now, this sort of thing comes up more, doesn't it?
Gemma likes a little bit too much.
I do. I love my aerial plans, but we're seeing these sorts of things all the time, where it wouldn't necessarily have been picked up before until it was a problem.
Yeah.
So on this particular one, as I said, they were absolutely certain that they owned this parcel of land. We don't find any documentation that reflected that, just nothing at all. So we went around the houses and eventually managed to locate a document which showed that they didn't actually own it. They had a license over it, and there was something in place from sort of 12 or 15 years ago, something like that, that no one who was a current owner or practice manager could remember having signed. And because it wasn't with their title documents, it just didn't make, it wasn't immediately apparent. There was nothing registered against the land registry title because it's not something that you would expect to be registered. And so there's this assumption that because these days we have the land registry, you don't need to keep anything. That just is not true, is it?
But we're coming on to something called a portal in a minute, which might help you in terms of keep track of things. But yeah, it's really important to keep a nice file of all these things to hand, as they may need to be referenced in the future.
Absolutely. And things like with leasehold land, keeping track of any licenses that you've had for alterations, and other bits like that is
And schedules
really
of
important.
condition.
Schedules of condition, assignment documentation. You might think that everything's been done and ticked off because something's been registered at the land registry, but that doesn't necessarily tell the whole story. So make sure you keep hold of stuff and make sure you know where it is. So the next case study, again, we've got another little plan there, similar sort of situation. Again, we were instructed to transfer a title from a retired partner to continuing partners, and parcel A was what we were instructed on. Again, it covers the vast majority of the property, but there's this section in green, parcel B, which was unregistered. Now, they're pretty confident that they had title deeds once upon a time, but again, nobody could find them. And it may be that they were lodged with a bank or with a former solicitor or something like that. But there was no obvious record of it within the practice. And so what we've had to do as part of this, this transaction is to apply to the land registry for adverse possession. It might be something you might think of it as squatters' rights over parcel B. So collecting lots of documentation and evidence to show that the practice has been in occupation of this parcel of land for however many years they've been there. And hoping that the land registry will agree to register it, because it's not a foregone conclusion that will happen. Again, another situation that would have been far, far easier and quicker if those title documents that everyone thinks exist somewhere could be located.
Yeah, it does come up a lot, and it's usually on refinance.
Yeah,
where these matters come to light, and then again costs escalate because it does take a while to unpick these things.
absolutely. So there's obviously lots of ways to keep track of your documents, and this isn't a sales pitch, but it's an indication of the sort of thing that you can do. We've recently launched something called the VWV Connect portal. And part of that is a shared document system, so that there's a central place for you to keep all these things, like your title documents, like your licenses and other leasehold arrangements, like any indemnity insurance you might have, and so on. And so if that's something you think you might be interested in, then please do get in touch, and we'd be very happy to organise a demo with you. But I won't
but we'll try and
stay on
include
it too long.
in the email coming out at the end a link if you are interested in specifically on that, and we can follow up with you on it. But it helps keep the house in order. So.
Indeed. So moving on, I think you're going to talk about funding. We've had a lot of instructions in recently about different funding things, haven't we?
We have, and of course underpinning all the funding is the lovely premises cost directions, and after a very, very long period of waiting for new ones, they finally popped up last year without much warning. They are in place and are being implemented, and they are a little bit different. And I just want to highlight two key things really for you as GPs, as the contracted practice, to think about. The first one is timescales. So there is now a 12-week deadline for you to challenge when the DB either reviews your notional rent, or on a rent review application where you ask them to approve the rent that you've agreed with your landlord. You've got 12 weeks from the decision of the DB to challenge that. And if you miss that, that's a strict deadline. And so you are at risk then of not getting the amount you were hoping to get for your notional rent, which means you're just a bit out of pocket. But more importantly, if you're a tenant, you may have a gap between what you're being charged by the landlord and what you're recovering from the NHS. So it's really important that within that 12-week period, you take responsibility for making sure that response goes back, even if it's just to say, we don't quite agree with you, we want to challenge it and agree some extended timescales. But a response to them in that period is really, really important, okay? And that's for you to do as a contracted practice, not the landlord, not a third party, it's on you, okay? The other thing under the directions is a leasehold point. And so on a rent review under a GP lease that's subject to an open market rent assessment, there's traditionally been a practice where actually instead of the practice talking to the DB to get the rent reviewed and get it approved so make sure it aligns with the CMR assessment, you just let the landlord talk to the DB and they get it all sorted out. Under the new directions, you're not allowed to appoint the landlord as your agent. So the responsibility for running that is actually yours as a contracted practice, which is a change, okay? So it's going to be really important for you going forward, if you are a tenant of GP premises, to make sure you properly diarise your rent reviews, You take early advice from a professional healthcare specialist, healthcare surveyor, okay, who will support you in this process and guide you through the timelines so you don't miss the deadlines, and also run that process. Now, under new leases being put in place, all of this will be at the landlord's cost. But at the moment, for old leases, where it assumes you're giving it to the landlord, there is a bit of a gap there in terms of what the lease says and how in practice you're meant to now run it under the current directions. So it's just being clear with the landlord they're paying for everything and keeping everyone in the loop and getting early advice as to what your responsibilities are in respect of that rent review process to make sure that the CMR assessment is signed off properly and you don't have a gap between what you've got to pay under your lease and what's being reimbursed. Okay. The next thing we just wanted to cover off was actually grant funding. So we're getting lots and lots of inquiries about grant funding at the moment, and the main ones are, of course, the UMF, the Utilisation Modernisation Fund, which are coming through. Now, there are others as well, so community interest levy grants and Section 106. We're seeing a lot more inquiries about those, which we have more so than in recent years as well, coming through as everyone tries to improve their premises at the moment. Just on the community interest levy and Section 106 side of things, so it's a bit trickier sometimes to get funding from that unless there's a specific scheme being built. However, we were talking to our planning team recently in response to an inquiry from a client, and they did suggest that actually there are pockets of money sitting around in councils, which you think would all be empty by now, but they're not. And so if there is some historic pots around, it may be an opportunity to contact them and say, is there any money that's been ring-fenced for healthcare that hasn't been used? If so, we'd love some because we've got an increased population. We want to spend it on our premises to service that population. Please, can we have it? Now, to keep costs down, you can contact your local authority directly and raise a direct question on this and say, look, we're a practice, we need to expand. Is there any money available, either under community infrastructure levy or Section 106 pots? And you never know, you might get lucky.
And even if there's not something already available, it may mean that you're then at the top of their mind when there are other developments coming through and more planning arrangements being agreed.
Yeah, so it's just something to maybe get a letter off. Might not hear anything, but it might be an option for some additional funding if you get lucky. The main thing, however, we are seeing is these UMF grants, and they are proving they're presented as standard form, and they always are. But unfortunately, the ancillary paper that comes off them is a bit more tricky than that. And the key things to remember are the guaranteed periods of use, which is linked to the level of funding that you get under these grants. And the level of funding also triggers how much control the NHS want over your title to your property and whether they want charges in place, restrictions on title, etc. We're going to come on to the next two slides about the specifics relating to freehold and leasehold. But the key things to bear in mind really are having your project information document, your PID documents. If you are thinking you might want to do something for your premises, these grant funding schemes come around quite regularly, different guises. They always have really strict deadlines.
Really short timescales.
Current UMF one has to be spent within the current financial year. So by the 31st of March, 26, the UMF pot of money is meant to leave the NHS account and go where it's supposed to go, be allocated. We're literally in the middle of a whole raft of UMF grant funding applications, which are still in progress. They're not starting the works yet. So we're going to have to front load a lot of those payments to make sure it leaves the NHS account. But the best thing to do if you're thinking of works, if you think you've missed the UMF deadline, is get that PID document signed off, get some healthcare survey support in terms of what you might want to do at your premises to improve them, and just have it on file ready for the next one. And then you can hit the ground running. Take early advice from us in terms of what it might mean in terms of your title paperwork, what you might have to do with your bank, your landlord, etc. And just be ready to go, really.
And also keeping your title updated. I know I keep banging on about it, but it makes it so much more straightforward when you have these short deadlines, if you don't then have to chase retired partners and so on.
And in terms of the last thing for this slide really is partnership agreements. So if you have got grant funding in place, including abatements, obligations in terms of signing up to these grant agreements where you're personally liable for, and actually if you don't continue to provide healthcare for the guaranteed period of use, you have to repay some of it. You need to make sure your partnership agreement covers that and obliges partners when they join to sign up to those arrangements. And when they retire, obviously you allow them to leave, but also just to make sure everyone's on the hook for those things if they're a full partner in partnership. Now, moving on to the next slide, it's just a bit of a case studies really around the freehold and leasehold and what we're seeing on grant funding, the type of issues that come up. Because again, as I mentioned earlier, they're often presented as a standard form NHS document. We just got to, we just let you know what it means. But they're never quite that straightforward, mainly because of the property arrangements that sit behind them. So for freehold premises, so where you own it outright, it can be complicated. It depends on the level of grant available, but often, even for smaller grants, the paperwork involved in sorting it out is sometimes disproportionate. It's whether the grant's $1 million or 100 grand, it's the same amount of paperwork you need to put in place often. So that's just worth bearing in mind. Now for freeholds, we always recommend to get legal advice before signing up to them. The value does not inform how complicated it gets. And the process we've got at the moment that we understand they're doing is the NHS solicitors will carry out a title review. We've managed to speak to them and agree that they don't need a certificate on title, which is fantastic news on this occasions for the UMF, which keeps costs down and a little less complicated. But if it's over £144,000, the NHS do want a legal charge over your freehold. And this causes some problems because most of you, if you own a freehold, will have a bank legal charge in place already, one of the healthcare banks, I expect. And so there's a priority for the first bank in place, and the NHS will be a second charge on that title. And to govern the relationship between the two of them when things might need to get called in, if you're struggling, a deed of priorities to be agreed between NHS and your existing bank. They're not always the most straightforward to agree. We're trying to agree with the banks, sort of a standard form that we can apply to these situations with NHS England. But as we mentioned earlier, all your GP practices, all your scenarios are slightly different. And some practices will have more equity, which makes the bank be a little bit more relaxed, and others are mortgaged 100%, so it makes it easier for partners to come and go. So we're having to deal with those on a case-by-case basis, and they can take time to resolve.
And of course, if you have borrowing with a more unusual lender, then they won't necessarily have that standardised process, will they?
Absolutely.
They're even thinking about it.
And as Gemma's always mentioned and several times, if your title isn't up to date, this whole process of just getting your grant funding signed off may trigger a title update, which may trigger a brand new legal charge or a variation of the charge you've got in place to bring that title up to date in order for the bank to approve the current situation and the second charge going to the NHS. So it can be a little bit more tricky than you were thinking. Also, for grants over 144,000, the NHS are actually asking for warranties at the moment in respect to those works. So that's another layer of paperwork we have to consider and make sure their standard form of warranty is available from your contractors, and we can support you in sorting that out. Now, my next slide is leasehold. And so same sort of process applies, standard form, grant agreement. However, it gets a bit more tricky here because we've got other players involved. And what we're seeing is for some of the smaller grants, again, presented, it's going to be really easy. Just let's get some advice on this grant agreement. NHS don't require a legal charge. However, they do have the guaranteed minimum period of use. And we had one just yesterday where, unfortunately, the lease term left is 5.5 years. And the minimum guaranteed period of use required is 6 years. So in order to get a grant of us under 144 was basically going to require a reversion release to go in place to extend the length of occupation that the practice is guaranteed to use that building for, which actually generally for practice is a good thing because obviously it gives them security, but they weren't quite planning on doing that just yet. But it's brought that discussion on a bit earlier. So reversion release has to go in place. They need to get the consent of the landlord for the works. Luckily, the lease does allow it in this occasion in terms of doing some alterations to refurb the building. And all of those take time because the landlord has to consider it. The landlord might have a bank that has to consider it. And so we've got to factor in all of these delays in terms of getting these consents lined up. One of the other things to think about with the leasehold grants is that usually the DV requires that any improvement works you carry out are disregarded when the rent reviews happen because they don't want to have to pay more money even though they pay for these works themselves. Most rent review clauses generally do exclude improvement works. However, if it's not in your lease, you're going to have to vary your lease on top of getting the landlord's consent to make sure it complies with the DV's requirements in respect of that grant. So as you can see, while it's presented as quite straightforward documentation, there are lots of different things that can come out of it. And again, if it's over 144,000, the NHS want to charge over your lease might not permit charging, so then we have a problem, have to get specific consent from your landlord or get the NHS to agree they don't need it on this occasion. And we need consent from the landlord, if you are allowed to charge it, to complete that charge. So basically, early advice is really key. It will take a bit longer than you're expecting because it's a little bit tricky. But we're here to support you on that and talk you through what's necessary. But being organised for the next time round, if you've missed out on this round of UMF funding, will really help you in the future. And we're happy to, again, have any chats around how we might help you do that. Okay. The next thing I think is our last slide. So if we pop onto that, Amy, it leads rather nicely. Yes, it's a favourite phrase of our boss Ben Willis, isn't it?
It is indeed.
Go for it, Jem.
So right team at the right time. So we've talked several times this afternoon about having specialists involved. So a specialist bank, a specialist accountant, a specialist surveyor, a specialist solicitor. People who actually know the sector, know the intricacies of these things, and also know each other. We're very regularly having conversations with our counterparts about how to make different schemes work. And so if you can develop those relationships with the people that you trust to help you in these matters, that's really key, isn't it?
It is. It's absolutely key. And I think it's also being prepared. So if you've got these guys on your books already, so if you've got an accountant, surveyor, banker, solicitor that you're happy with, you trust, when things come up, you can really just feel free to pick the phone up and ask those questions. With the premises cost restrictions changes, your survey is really, really key, particularly if you're a tenant, to make sure you've got that relationship with them and they're watching your back in terms of the timescales when reviews should be happening and when action should be taken. You know, and similarly for us, we take phone calls all the time from clients that we regularly work with, which actually isn't a legal question, but we can signpost them to the right people.
Yeah.
And say, you know, you've got to do X, Y, and Z before you come back to us. We'd love to help, but it will cost a bit much at the moment. Usually is what we say. Go and figure it out and then come back and we can take it from there.
But the key is that early conversation with your advisors to make sure you're speaking to the right people. So yeah, if it's about the legal documentation, we can obviously help, or we can point you to your surveyor if it's a valuation point or whoever it might be. But having that team around you, you've got your day job to worry about. Let your professional advisors worry about all of the peripheral stuff and to advise you on it. So we're running quite close to the hour now, which has flown by, and we've had quite a few questions in, which is great. So we'll cover off a couple of those.
Passes on.
There's one here which I think we've already covered off about the NHS taking charge over premises when there's grant funding. Hopefully we've covered that question for you around if there's already bank financing in place or we're doing refinance, then there'll have to be a deed of priorities for those different charges where a charge is required.
And just on that, I think the threshold is around about the 144,000 mark for where they don't need a charge or need a charge. So if your funding is under that, you should be able to get away with not having a charge, just a restriction to back up the grant agreement on your title. But above that, they are requiring charges at the moment.
There's one here. When change occurs in shareholding, doesn't the solicitor update the title as legal papers are signed? Yes, if they're instructed to do so, is the short answer on that. Your solicitor won't necessarily automatically know that this needs doing. So you do need to keep that dialogue going. Speak to the solicitor, speak to the bank, make sure that everybody knows that this stuff needs doing. And once your solicitor's instructed, then of course that process will follow.
I think it's always worth, if you're getting your partnership agreement updated, just always ask the question what property work he's doing at the same time. Because again, if you're in isolation asking a partnership lawyer to do that for you, they should really refer it to whoever they're working with, but it doesn't always come up. And sometimes for a cost reason, it's just specifically this, and you've already paid the partner out or done whatever you think you're doing, and you don't think it's required. So always just check and ask for a bit of a once over on the paperwork to make sure it's all covered off.
Absolutely.
What else have we got here?
So we have a GP partner retiring and we have a partnership owned building and a lease building. Do we just need to update the paperwork, or is there more to be done? So it will depend on exactly what your title document says and what your lease says. So if you have leasehold premises and you have a lease in place, please be reassured that you probably don't need a new lease. It probably won't be a full new lease process. Most leases you can assign, so that's essentially the same as transferring. But again, it's something that just ask a question, and we can let you know what our recommendation is for your specific situation, because it always varies, doesn't it, depending on exactly what
it does vary. And so partners retiring, you've got to think about partnership agreements and make sure you follow that in terms of their exit. One of the things that has been coming up quite a lot recently, if you've got a leasehold premises, is whether the partnership's been keeping a little bit of pot of money aside to deal with dilapidations. The dilapidations are at the end of your lease. You're supposed to return the building or have it ready to be returned in the repair, compliance and compliance state that you're meant to be keeping it every day. Now, under a lease, you're always going to be in breach, there's always going to be something wrong. But actually, even if you're going for a renewal, that at the end of the lease, just before you enter the new one, it's a really good point to just stop and go, where are we? Are we up to date with everything? And if partners are leaving around about that time, it's only fair really that they've benefited it for 15, 20 years, that they contribute to the cost of putting it back in repair. And often it's not covered in partnership agreements, and there's no pot of money being accrued, because I appreciate there are tax consequences to that sometimes. We're not here to advise on that. Please speak to your accountants. But making sure that actually if someone is coming up to retirement, that they have properly contributed towards those things before they go. It's important to have those conversations and have it factored into that assessment.
We've got this one, which isn't so much a question as a comment, and I think it's quite interesting, is that with grant funding, it doesn't increase your notional rent and there's no uplift in the property value as a result, and can put you into negative equity, which is not very attractive for new partners, which is, it can be the case, but hopefully the works that are backed up by this can themselves attract your new partners and the future prospect of that increase, because the minimum period of usage is necessarily a specific period. It's not forever. And so whilst yes, you've got to consider these things sort of globally, there are different benefits and risks associated with any of these things.
Now that's my timer telling us we're up to 2 o'clock, I'm afraid. There's some really great questions on here. So thank you for those, and we'll have a look through those and perhaps put a summary, the follow-up email of some key things.
Absolutely.
If there's something really burning question there you want to answer, please do contact us and we will get back to you separately on that. Thank you for your engagement. That's really fantastic.
This is us, Gemma and Rebecca, yeah, if you've got any follow-up that you'd like from us, then do let us know.
I do have a very nice, helpful comment from Tim. Tim's written, may be useful to the audience to know that you can mix and match a MIG with an UMF to keep NHS part below 144k, which is always really good to know. So I've had a few practices actually who have decided to put their own money in just to keep it under that threshold, so they don't need the charges and get the deed of priorities and incur all that side of it. So there is yeah, you're right, you can get pots of money from different things. Thank you, Tim, really helpful. And thank you all for attending.
Yeah, thanks very much. Have a lovely afternoon, and we look forward to speaking to you again.
Super. Bye-bye. Bye.